Gentleman yields back. I now give myself 5 minutes. Witnesses. For many small and medium private companies considering an IPO, the decision often comes down to whether the benefits of assessing public markets outweigh the risk of compliance. But as we have seen in recent years, the shareholder proposal process can be dominated by a small group of activist investors advancing niche political agendas that have little to do with long-term value creation. At the same time, proxy advisory firms wield outsized influence over voting outcomes and operating with limited transparency and potential conflicts of interest. So together, these dynamics can create an uncertainty and additional costs that make public markets less attractive. So, Mr. Copeland, can you explain why the existence of both radical shareholder activists and proxy advisory firms can be a deterrent for small and medium cap companies that are looking to go public?
Certainly. I mean, at the end of the day, you've got these activist forces empowered by, an SEC rule that are trying to tell you how to run your business. And it's important for shareholders to have oversight, but why do we have shareholder voting rights? It's not to create mini democracies with companies. You don't have to be an expert, I say this in my testimony, you don't have to be an expert in public choice theory to understand that, it's hard for the political process to work efficiently. It's good that we have representation here, but this is not a body that's known for its efficiency. Businesses need to be efficient. So if you're trying to run a business, I mean, certainly we want them to come to public markets. It's a good way to allow original founders of the companies to get liquidity. It's a good way to allow everyday people on the street to get a piece of those returns. And when we're making it harder and harder for these public companies to do that, it hurts the average investor out there as well as the company's returns themselves.
Sorry, as we have seen in recent years, the proposal process has been overtaken by activists who file dozens of proposals, many of them pushing political or social agendas that are far removed from adding shareholder value. Boards are spending hundreds of hours each proxy season dealing with these kinds of proposals, and while companies are dragged into debates over climate policy, DEI, or other issues that have no place in the boardroom, this politicization undermines the very purpose of shareholder oversight. So, Mr. Mueller, how do you distinguish between a proposal that is a legitimate tool for corporate oversight and one that is an illegitimate tool to make a political statement?
Sure. Well, certainly corporate governance is the relationship between boards and shareholders, and we've talked about some of the good corporate governance shareholder proposals. But when proposals start interfering with how a company is running a business, and not just asking for information about that, but really seeking to dictate what actions they take, whether the company is pursuing a certain climate change strategy or not, and really remove that from relevance to the company business, those proposals are clearly an activist proposal.
Okay. In recent weeks, the U.S. District Court for the Western District of Texas, my state, entered a preliminary injunction against the Texas law, SB 2337, which would bring transparency to the proxy duopoly by requiring these firms to file disclosures when their services are based on non-financial factors such as ESG or DEI considerations. Recommend a vote contrary to company management's recommendation to provide conflicting advice across clients. So, Mr. Copeland, again to you. What benefits do you see as a result of this legislation if implemented, and how can transparency bring balance to proxy advising?
Yeah, I think it's valuable to have transparency in this market too, right? I mean, at the end of the day, we have these voting rights because of agency costs. The people running the businesses aren't necessarily going to act in the best interest of the shareholders. That's why we want these voting rights. But these proxy advisors have more agency costs. So, ultimately, I think a federal solution here would be better. But it makes sense that in the absence of federal action or with legal contestation and withdrawals of various federal action in this, that a state's going to stand up for it. And again, corporate governance should be a state-level question. Disclosure, this is what my Yale law professor Roberto Romano called the genius of American corporate law. Disclosure at the federal level, substantive rights at the state level. This has worked. This is why we dominate world capital markets, and all of these trends are undercutting the secrets of that success.
Thank you very much. I yield my time.